Our last case of the morning is Progressive Marathon versus Pena. Good morning. This is a 15-minute mini oral argument on the application. You may reserve time for rebuttal, but we ask that you keep track of your own time, and you may begin when you're ready.
May it please the Court, Steve Hicks on behalf of the defendants, appellants Pena, John Pena and Crystal Sewell. I would like to reserve 2 minutes for rebuttal if I can. Seated to counsel table to my right is Stan Feldman. He was my co-counsel in this declaratory relief action. He is also the trial counsel in the underlying tort action. I want to say at the outset that I represent only defendant appellants Pena and Sewell. I do not represent Giddings, who is Progressive's insured. But I would want to note that the coverage issue is significant not only to Pena and Sewell, but also for Giddings, because the damages in this case are high in the underlying tort action, and therefore the exposure for Ms. Giddings is also very high. The question asked in this case, and just by way of background, we're dealing with an auto policy that was issued before July 2nd, 2020, with only $20,000 and $40,000 in liability coverage provided. The policy extends beyond that date, extends beyond July 1st, 2020. The motor vehicle accident happens after that. So the court has asked the question, are the higher liability coverage limits of $250,000, $500,000 that are owed under the amended No-Fault Act, are they owed in this case, whereas in this case the insured caused the motor vehicle accident after July 1st, 2020. It's not often in my 15, 20 years of practice that I feel as strongly as I do in this case that I have the textualist high ground, so I think I'm going to try to claim it. I'd like to take a look at MCL 500-3009 sub 1. This is the section and is the only section that mandates what the liability coverage limits should be. The language is actually very clear. I would say it's clear and unambiguous. It says, and I'm going to paraphrase some of this, but I'll tell you what I'm quoting, that auto policies must not be, quote, delivered or issued for delivery, unquote, in Michigan on motor vehicles registered or principally garaged in Michigan, and then quoting again, unless the liability coverage is subject to all of the following limits. And I'll come back to that phrase, all of the following limits. It then goes on to say what those limits are. And it's a little unwieldy in the way they do it with the sub A and sub B, because they focus on the per person limit in the first section and the per two, when you have 2 or more people in the second one. But basically the gist of it is that before July 2nd, 2020, 2040 is okay. After July 1st, 2020, $250,500 is the mandated amount. There's a caveat.
So I appreciate you going and studying, I should say, the text of the statute. And 3009 sub 1, I'm having a hard time saying that the heightened limits apply. When I read it in total, you left out with the exceptions of subsection 5 and 8 at the beginning of that subsection.
Yes.
And both of those sections specifically refer to that they cannot take place until after July 1, 2007. So, I'm sorry, 2020. So what are we to make of that reference there?
That was the very next point I was going to get to. Because you're right, I mean, 3009 sub 1 does have this caveat right at the beginning of it. It says subject to subsections 5 through 8. And 5 through 8 are very specific. They are what I would call the opt-out of that mandated amount. 3009-1 mandates $250,500 after that date. But then subsections 5 through 8 say, yeah, but we're going to give you an opt-out where you can choose. You'll be informed of this, and you can choose to get less coverage as long as it's more than $50,000, $100,000. It can't be any less than that. So that there's this opt-out. But 5 through 8, all of that caveat, and it is separate from the mandate. The caveat is specific that it applies to policies issued or renewed after July 1st, 2020. That is not this case. This case is a policy that was issued in March of 2020 with a 6-month term. So I think, having explained the caveat, I think there's 2 important points that need to be recognized here. And we're basically trying to get at the legislative intent. And with regard to the legislature's intent in adopting this provision and increasing the limits to $250,500 and mandating that amount, there's no real dispute in this case that the intent was to protect insureds from increased tort liability. PIP choice was coming in, some or all medical bills were no longer going to be covered, and the tort action, you were going to be allowed to sue for those. That's the fundamental change that was made. The size of the increase, and defense counsels harped on this in their brief, 12 times, it increased it 12 times as much. It's true, it did, it's a lot, and that's what the legislature chose. Why did they choose that? Because the risk had grown so much on tort liability when you went to a PIP choice system. The question is, and the thing that I think is undisputed when it comes to legislative intent, did the legislature intend for insureds like Giddings to go unprotected? No, they wanted them to be protected. They wanted all insureds to be protected. That's why they set the mandate at that level for policies that extended for anything after July 1st, 2020. Progressive didn't do as the legislature intended. It went on with business as usual. It wrote a 2040 policy knowing the law had changed, not informing its insured that, hey, in the middle of your policy, the law is going to change and suddenly you can be sued in tort for more than you would have been under the old law. So the legislative intent was very clear, and I don't really think there's a dispute that the legislature did this. They set this very high mandate of $250,500 because they wanted to protect insureds from increased tort liability. So, okay, that's their intent. Does the statutory wording support me? As I said before, I think from a textualist perspective, and looking at the words in 500, 3009,
Let me make sure I
sub 1,
understand the facts here. The added protection here for increased tort liability was because there was no longer lifetime PIP coverage.
correct.
But your client has lifetime PIP coverage.
Yep, factually that is an anomaly in this case.
So the legislature made a mistake?
No.
They provided extra protection for people who don't need it?
No, my clients are not representative of every claimant that's out there. My clients happen to have been motorcyclists, and no fault is weird when it comes to motorcyclists. You have to go claim through the vehicle that was involved in the accident. So they end up claiming, oddly enough, through Progressive, and their PIP benefits have been paid. But that is, and this court often says, we need to write a rule that works for everybody. We don't just look at the facts in your case and fashion a rule. If you were to do that, you might say, well, gee, I'm not worried about these plaintiffs. They got PIP benefits. But not everybody's going to have that. There will be people, every day you get past July 1st, 2020, somebody is changing their policy, they're getting out of their PIP, and they're going to be able to then sue someone who may well, and there are other cases out there where Progressive has only written 20.
So this holding, whether we were to affirm or reverse, would apply to a narrow category of individuals, right? I mean, like, what I sort of refer to as like straddle policies, right? Like they were issued arguably knowing that they were going to cover a period in which some of these changes go into place. Go after for policies issued, delivered, renewed, all of that after July 1 of 2020, there's no dispute that the higher minimums apply and the other provisions.
Higher minimums apply, but they will have been given the choice to opt for less, which still would have been 2.5 times as much coverage as Progressive is providing to Giddings in this case, because it would have been $5,100. The problem is that the statutory mandate, and I want to be clear on this, the statutory mandate says it's $250,500 unless you do the things in subsections 5 through 8, those opt-out provisions. Those were never explained to her before this change happened on July 1st. She never got an opportunity to do that. It was only at her renewal that she did that, and she did actually opt
Could
for the lower
Progressive have
amount.
decided not to issue a straddle policy and like issued it from, I'm going to give you March to July 19th?
Certainly,
And
not
then
all,
I'm gonna do a
yeah.
policy afterwards, and different choices and different premiums might apply?
Yeah, not all policies are 6-month policies, and policies often change during the interim. You may add and change vehicles, policy rates may change, and you know, the Progressive has tried to suggest that it would have been impossible for us to do this. I find that suggestion puzzling, given that they had to do exactly that after July 1st, 2020. They had to do exactly, and they had to use the DIFS forms. Before this, they didn't have to use the DIFS forms, but my position would be they had to inform their insured of the change that was coming and say, hey, here's what's gonna happen to your policy. Your rate's gonna go up because we have to give you $250, $500, or you can opt out. And ultimately, DIFS, a few days after July 1st, it's like a week later, issues a bulletin that says, consistent with our position, you have to offer to your existing insureds with these policies that are currently going on, you've got to offer it to them that they can make these choices, both PIP choices and liability coverage choices.
Right, but that's on them to make the choice. It didn't mandate that the insurance company terminate the policy, did it?
It didn't say terminate the policy, you do a midterm endorsement, but the whole notion that it would have been unwieldy or impossible or burdensome for the insurance industry to do this is not accurate. Because in fact, one of the sections they cite that also uses the July 1st, 2020 date, 500-211F, says you got to create all your rates that you're going to use, and you got to get them approved if you're going to use different rates after July 1st, 2020. So they're all gearing up to do this anyway. It basically comes down to math. And it comes down to, if you're going to do that, it's probably going to be an increase in premium for the insured, and you're probably going to want to give them the option of going with the 5100. So if there's an increase, it isn't quite as big. But
Are you familiar with our case from last term, Andary versus USA?
Very familiar with it.
So is your interpretation, did you have problems with that case? Seems to me your interpretation of how the statute should read is contrary to Andrew.
I don't understand how the reading of this provision, which deals with liability coverage, would have much of any bearing on.
Well, the court said the law in place at the time a contract is entered into is tied to the contract terms. And so if we take that literally and look at the statute you're presenting to us, it seems to me that it's difficult to get past that.
I don't believe so,
magic
because
change on July 1.
I don't believe so, because the law in place, I mean, the amended No Fault Act didn't come in 2020. It came in June 11th, 2019. So it's not like everybody didn't know of these changes. And what was the law that was in place? The law that was in place said exactly what I've just read to you from 500-3009-1. It said before July 1st, 2020, it's got to be you got to have 2040. That's it. But after July 1st, 2020, the mandate was higher. So it's absolutely consistent with the law that was in place at that time. And fundamentally, and I'd like to point out that Progressive never responds to this point. The 500-3009 sub 1 says, and I said this earlier, unless the liability coverage is subject to all of the following limits. All means all. And they never respond to that point. The Insurance Alliance in their amicus says, well, but it always said all, and they just kept it in there, but it's in there, and it needs to be read. It has meaning, and it can't just be ignored because it was previously in this statute, and it described 3 different types of limits that applied before. Progressive never addresses that. Only the IAM does it, and they do it on what I think is a meaningless point of, oh, but it was there before, just disregard it. At this point is essentially their take on the case.
Isn't the more natural reading of the statute that the limits are tied to the date that the policy is delivered or issued?
That's where the court
That's the verb.
That's where the Court of Appeals decided the case. But basically what they're doing is the delivery is in sub 1. It talks about, and I said this before, issued, delivered, or issued for delivery.
That's sort of the main clause, right?
Sub 1. And it doesn't say anything at date. There's no date there. There's no date in 1 saying issued or delivered before July 1st, 2020, issued or delivered after. It doesn't say it in that clause. It just says issued for, or delivered or issued for delivery, you got to have the following limits. And then it tells you what the limits are. And it's in the limits that it describes what you must have, and it tells you that you must have both of these, all of the following limits. So that's fundamentally why I think we do have
Were
the
insurance
textual tiger.
companies issuing staggered policies?
Pardon me?
Were insurance companies issuing staggered policies based on this language? Is that how you're saying Progressive just missed the ball here? Did
Yeah,
everyone
Progressive
else not drop the ball?
Progressive Marathon is the defendant in most of these cases. They could probably explain it better why that is. There are other companies as well, but I believe that there were companies that were making the adjustments. There certainly were companies that were going to make those adjustments after DIFS gave them a warning 1 week later and said, you got to make this available.
What, did DIFS interpret the provision this way such that they required the stepped-up policies that you're discussing?
Well, DIFS, I think in fairness, is all over the map on this. We haven't heard from DIFS in this case, interestingly enough. But DIFS, in answering frequently answered questions, a question was asked about this subject, and they answered it, I think, the way the defense would like to see it answered. But on those frequently answered questions, they say, this is not legal advice. So basically, they're saying, you should go talk to your own attorney. The fact that the question was asked alone suggests to me that there was enough confusion on this issue that insurers, Progressive, and others that continue to do this should have taken a hard look at that provision and said, no, I think we need to inform our insureds the law is changing and tell them what they need to do to keep the minimum, which will now be $5,100. They've got to do something. They've got to check off the box, as they later did under the caveat, the opt-out provisions.
Counsel, I want, just,
Yep.
One more question. Are you, I want to make sure, are you acknowledging that if we agree with your position, that individuals with straddle policies also have increased exposure to tort liability?
That those with straddle have increased exposure?
Yeah.
Sure.
Because that
sure.
was, obviously the increased coverage was taking that into account.
Yeah, that's
Now-
why they did it. That's why they did it. And by happenstance in this case, Ms. Giddings is not being sued for PIP benefits. But this case is not every case, and the court
Right,
needs to.
understood, right.
Okay.
All right, thank you.
Yeah.
Thank you.
Thank you very much. I appreciate it.
Good morning. May it please the court. Jeffrey Garish on behalf of Progressive. This case presents an issue of statutory interpretation, the goal of which is always to discern what the legislature intended. And so the question boils down to basically this. When the legislature amended 500.3009 and said that for policies issued after July 1, 2020, the default minimum limits are $250,000, $500,000, did they intend that policies issued or delivered before that date are subject to that higher limits without saying so? That's their position. But the legislature didn't just not say that. They literally said the opposite in subsection 8 that Justice Zara astutely asked about. Subsection 8 specifically says, after July 1, 2020, if an insurance policy is issued or renewed as described in subsection 1, it's subject to the higher default limits. Their position is that the legislature meant the exact opposite. They meant both after and before. That provision not only serves no purpose, it has the effect of the ultimate head fake in deking out insurers and DIFs, by the way, into thinking that this only applied to policies issued or renewed after July 1, 2020, because of course that's what the legislature meant. And the Court of Appeals got it exactly right in recognizing, and they used the perfect phrase, I thought, that when the statute is construed in its grammatical context, it's very clear what the legislature meant. The legislature intended these changes only to apply to policies issued or renewed after July 1, 2020.
Why did it not use the same words of issued or renewed, instead referred to in this provision, delivered or issued for delivery?
Well, I will concede it's not the most artfully drafted
But you're saying that
statute.
means the same thing, that
I
it's clear.
think it does mean essentially the same,
But
issued
they
or
use
renewed.
different words. And so
They
how
do.
do you tie delivered or issued for delivery to the dates of, in sub 1, delivered or issued for delivery? How do you tie that to the dates in sub A and B?
Because the operative verbal clause in subsection 1 is delivered or issued for delivery, and then the dates that they put in are tied to when it was delivered or issued for delivery.
But it says unless delivered or issued for delivery in this state, it can't happen unless the liability coverage is subject to all of the following. So why do A and B not modify the coverage as opposed to the delivery date? Because it doesn't say, delivered or issued for delivery before July 20th or July 2nd or after. It says the liability coverage is tied to the dates.
Yeah, and I think it's the honest answer, Justice Kavanaugh, it's probably because they were amending the statute as existed in its prior form, and which talked about delivered or issued for delivery, and they just tried to tweak it to say if it's delivered or issued for delivery before this date, these are the limits. If after this, and they make it crystal clear in subsection 8. That's why I keep coming back to that, because there's literally no purpose of the first phrase in subsection 8 except to clarify when it says after July 1, 2020, that has no purpose other than to make it clear that it's only for policies issued or renewed after that date that the default limits apply.
You don't
Otherwise,
think there could be a difference between policies issued and renewed as opposed to policies that have already been delivered prior to that date, right? Because since June of 19, we knew that these limits are going to go into effect in July of 2020, and recognizing that some insurers may issue policies that straddle that period. So you may have an existing policy before that date goes into effect. It's been delivered to you, as opposed to an insurance company is gonna issue it or renew it after a date. So there might be existing policies that are gonna cover this straddle.
yeah, I guess I'm not following the distinction between, and no, I've never seen anyone suggest that there's a meaningful distinction between these, and Your Honor might be picking on something that no one else has picked up on. But I still think if you look at 8, it clarifies that this only applies to policies issued or renewed. Issued or renewed can't really be construed as materially different than delivered unless I'm missing something. And understand the import of what their position is. Their position is essentially this, that every insurer that writes auto insurance in Michigan was required to, number one, assume that DIFS was misinterpreting the statute that they are charged with correctly interpreting. They had to assume that DIFS misinterpreted the statute. They then had to foist these giant limits on their insureds on existing policies, whether the insureds wanted them or not. This is the thing. My friend, Mr. Hicks, cast this as benevolently trying to take care of Miss Giddings. How do you think Miss Giddings would have reacted if Progressive would have said, oh, as of July 2nd, 2020, your liability limits and your premiums are going to be going up by 12-fold. Sorry, the law changed. I mean, insureds don't want that. It's important to remember, these are minimum limits.
Could they
she
have
can
done
buy
that,
as
though?
much insurance as she wants.
Could they have charged a premium for the policy, knowing that these limits change, that would have, I mean,
Yeah,
they
well,
could, right? Nothing prohibited
right.
them from amending their policy limit based on the coverage risk.
And it would have been incredibly unwieldy. Mr. Hicks says it would have been impossible. I've never said it would be impossible, but literally what they would have to do under their position is issue a policy that has limits of 2040, if that's what the insured bought, as of, say, May 15th. And then as of June 2nd, 2020, the limits have to go up to 250,500. Again, whether they want it or not. And the insured wouldn't even be allowed to ask for the lower rates, the lower limits, until after July 1, because subsection 5 doesn't give that option. So every day, it would have to be a different set of limits that changes. There's hundreds and hundreds of potential combinations for one policy issued to one insured on one vehicle. And the notion that insurers were required to figure this out and price it accurately is nonsense, especially when DIFS did not require this. If Progressive had told Ms. Giddings, you know what, whether you like it or not, your limit is going up to $250,500 on July 2nd. She would have been, would have been furious. We already know because she tried to get the lower default limit as soon as she could. But B, a sophisticated insured, I think what they probably would have done is said, wait a minute. I went to the Department of Insurance and Financial Services. They tell me you're lying. They tell me you're lying. My limits don't go up automatically. This only applies to policies that are issued or renewed after that date. So they're asking the insurers to do the impossible. And it is contrary to the language of the statute interpreted in its grammatical context. That's what the Court of Appeals focused on, and rightly so.
Could they have issued a policy instead of a straddle policy that ended, we're insuring you to July 1, and here's the premium and that, and then here's the premium that will kick in on July 2nd, and here's the policy. Like, we're splitting this because so that we can do that. I mean, nothing prohibited those sort of split
I agree.
policies.
I think in theory they could have issued a 72-day or 71-day policy and then started it. They could have done that. But I think they were entitled to rely on how DIFS interpreted the statute, especially since we think it's correct. And I would add, this supposed concern for Ms. Giddings and others because they purchased low limits at their choosing and they had to have higher limits, I think it fails to recognize that, well, number one, the DIFS doesn't interpret it that way, but I just lost my train of thought. It fails to recognize the difficulty that insurers would face in having to do a different policy all the time, a policy that expires after a particular date. And it fails.
Were other insurance companies offering these straddle policies that opposing counsel suggested would have been the only responsible way to proceed?
Not that I know of. I mean, I think the reason Progressive is probably the party in some of these cases is we filed the deck action. I mean, we had the Progressive filed this deck action to try to flush this issue out. I don't know of any other insurer that did this, that assumed that DIFS was misinterpreting the statute. And by the way, the notion that DIFS is all over the map is not true. DIFS has been very consistent in saying this applies only to policies issued or renewed after July 1, 2020. It then also said, if you have insureds who want additional limits because their exposure is going up, you need to offer that. And in fact, MCL 500-2020 specifically requires insurers to put in the policies that this policy can be canceled at any time. So if they did insure someone who had a lot of assets and didn't want the minimum limits, but somehow they wanted the minimum limits before this date, but then they were very much afraid of the new exposure and they wanted higher limits, they could do that. They could do that. And that was how DIFS reacted. That's DIF's solution to protecting the supposed dramatic increase in exposure, because it wasn't dramatic. There would be no increase in exposure for anyone until people started to buy policies after July 1, 2020 that first allowed them to get less than unlimited PIP. And the exposure would have been gradual, especially on 6-month policies. It was going to be very few cases where the exposure was going to be such that people needed higher limits. And even then, nobody is prohibited from buying as high limits as they want. This is the thing that I think they keep forgetting. Anybody can buy as high limits as they want. And the notion that insurers wanted to sell people policies with the lowest possible limits also makes no sense. I mean, I represent insurers. I think they like to sell insurance. I think they'd be more than happy to sell policies with as high limits as people want. So the notion that Ms. Giddings was required to have this extra coverage is just not true. And DIF's solution was to remind insurers, you can cancel the policy whenever you want. If you're worried about this new exposure, you can get a renewed policy, you can get an amendment, we can increase your limits. And that was issued just a few days after July 1st. It was, I think, July 8th, 2020. That was the solution to the problem.
So if we were to agree with your position, what do we do, the individual tort liability that people were subject to, after July 2nd and after? So would that still apply here?
Yeah, I think the liability exists. I think it was going to be gradual because it couldn't exist at all until somebody bought a policy after July 1 that had limited PIP, then got in an accident, and then sued for the excessive PIP to the extent they didn't buy it. But again, I would just add this on the liability exposure. Mr. Hicks suggests that somehow insurers like Progressive had a duty to inform their insureds that their liability went up. No, they didn't. Why would they have that? Why would they have that responsibility? I mean, I think this court, I forget the name of the case, but changed the open and obvious doctrine that I think increased exposure to everyone who owns a store that could be sued. Did insurers all have an obligation to tell all their insureds your liability exposure goes up, so your limits have to go up? They don't have to do that. And again, these are minimum limits. So any insured that wanted to buy higher limits was free to do so, either before or after July 1st, 2020. All this talks about is minimum limits. So the only other thing I would say is, and I said this in my supplemental brief, it's an expression that I've always thought is helpful, that the legislature tends not to hide elephants in mouse holes. I mean, they're saying that not only did the legislature do that here, they really are saying the legislature intentionally faked insurers out and diffs out by putting in Section 8 that this applies only to policies issued or renewed after July 1, 2020, when in fact what they really meant is it applies to policies issued either after or before July 1, 2020. That's not what the legislature intended, and it's not what they said. If the court has any questions, I'll be happy to answer them, but if not, I will rest on my brief.
Any other questions? Okay.
Thank you.
Thank you both. The case will be submitted and the court is adjourned.